Think of the number 3. It's a unique and a prime number. It's perhaps one of the most used numbers in the world. The Holy Trinity, the Three Stooges, the Three Blind Mice, 3 bags full, 3rd time's the charm. Well, you get the idea. What does the number 3 has to do with the litigation process? Believe it or not, it is made out of the number 3. In Malaysia, there are 3 stages in a civil proceeding before one can obtain a judgment, namely pleadings, pre-trial case management, and trial. At the pleading stage, a suit is generally commenced by the plaintiff when he files and serves a writ and a statement of claim to the defendant. Upon entering an appearance to defend the claim, which is usually filed within 14 days from the receipt of the writ, the defendant will have 14 days to file and serve his defense. Thereafter, the plaintiff will then have 14 days to file and serve his reply. If the defendant has a counterclaim, he will need to file and serve it together with his defense so that the plaintiff can also file and serve his defense to counterclaim together with his reply. Pleadings will then be deemed closed. These 3 are fundamental to set out the background of the case, laying down the details of the claim, defense, and reply to the defense. At the pre-trial case management stage, the court will give directions to prepare the matter for trial. Parties will then be required to exchange documents or evidence at this stage and file any documents required by the court to assist it during the trial. Unlike popular belief, this is perhaps one of the most important stages in the entire proceeding. Apart from preparing the documents in accordance to the preference of the judge, however way that makes it easier for the court to understand the case, at this stage, the parties will be required to study the exchange documents, prepare a rebuttal, and collect the additional evidence within a short span of time. Once the documents are ready, the court will then fix trial dates and proceed with the trial. At the trial stage, the plaintiff will begin calling witnesses to testify for his case, followed by the defendant's witnesses when it's his turn to defend the claim. When a plaintiff's witness is called to the stand, the plaintiff's lawyer will first question the witness to elicit the required evidence to support the plaintiff's case. This is called examination in chief. After the plaintiff's lawyer is done, the defendant's lawyer will then begin his attack by questioning the plaintiff's witness in hope to discredit him. This is called cross-examination. The plaintiff's lawyer will then question the plaintiff's witness one last time to clarify any inconsistencies or uncertainties that were discovered during the cross-examination, and this is called re-examination. When a defendant's witness is called to the stand, the same 3-step procedure is repeated, vice versa. Once all the evidence is given, both the lawyers will then submit their arguments, whether orally or in writing, as directed by the court, before the court gives a judgment. Now, out of this main suit, parties can pursue various interlocutory applications to advance their case. An interlocutory application, also known as an interim application, is an application for a decision on a particular issue that can generally be filed at any stage within the main suit. This includes an application to amend the pleadings, application for injunctions, application for discovery, and so on. There are also some interlocutory applications out there that, if successful, help speed up the disposal of the main suit. Think of it like a shortcut. This includes an application for summary judgment, application for disposal of case on point of law, application to strike out, and so on. Unfortunately, we do not have time to explain what each of these interlocutory applications means. Perhaps another video for another day. Like the main suit, the interlocutory application also has 3 stages. The first stage is the notice of application stage. This sets out the prayers the applicant is seeking and the provision he relies on in making the application. The second stage is the affidavit stage, where the parties will file and exchange affidavits to support or rebut the application. Affidavits are sworn statements used as evidence in court. The third stage would be the hearing stage, where the lawyers will submit their arguments, whether orally or in writing, as directed by the court, before the court gives a decision. There you have it, an overview of the litigation process in a civil proceeding, or in the factor of 3.